You're on mute, Lou.
Unmute. Okay, can you hear me now?
Yes.
Great, thank you. Okay, all right, so your brand is basically your identity in the marketplace. It's what tells customers they can trust you, what sets you apart from your competitors, and what carries the value of everything you've built, from your reputation to your prices to your customer loyalty. If you don't protect it, you risk someone else cashing in on your hard work, customers getting confused or misled, and your ability to grow or expand into new markets being blocked because someone else got there first. It's less about chasing down every infringer and more about safeguarding the thing that your whole business is built on. The key point is that using a name is not the same as legally protecting your brand. So, next slide, please, Dina, thank you. Protecting your brand and reputation is bigger than just registering a name or a logo. Brand includes trademarks such as your business name, product names, logos, and other signs that identify your business. It can include creative assets such as website content, photographs, campaigns, templates, and designs. And it can include confidential information, customer data, pricing information, things that competitors would be pretty interested in. More than 97,000 trademark applications were filed in Australia last year. So people are trying to do the right thing, but even so, the risk is that legal protection is not put in place early enough. A name launched, a website is built, and a campaign goes live, but have you stopped to check whether your business can legally use, own, and protect what it has created? I'll now take you through 3 gaps that I see in practice. The first gap is usually the name. A business may have registered a company name, a business name, or a domain name, and they may assume that that means they own the brand, but it doesn't. We have had clients who've operated for years without the protection of a registered trademark. If you don't have your marks registered, it's not fatal, but it means that you may need to provide evidence to prove when your rights to the mark started, rather than being able to just simply show your trademark registration. One client of ours had operated for 20 years without a registered mark. Trying to register the client's marks after so long was actually really difficult. There were many marks with similar names that had been registered since our client started their business. So when we came in after that, we had to try and prove that our client existed in the marketplace before every single one of them. But that wasn't as easy as you'd think. Lots of evidence had been lost over the 20 years. A computer system change meant that photos and other evidence had just disappeared. So no registration is a serious gap. Another gap is where there's, I want to just explain that a slight change in spelling is not enough to avoid a claim of trademark infringement. One thing to be aware of is that ASIC and IP Australia don't talk to each other. ASIC will allow you to register a company name or a business name that is only slightly different from an existing company name or business name. However, the register of a company name, business name, or domain name will not give you a monopoly in the same way that to the mark in the same way that a trademark will. To illustrate some broader issues that arise in this space, I want to talk about the bed, bath and table example shown here in the slide. Bed, Bath and Table sued House, Bed and Bath for trademark infringement and also for misleading and deceptive conduct. The case went all the way to the High Court, which found that there was no trademark infringement because the word house was seen as being distinctive enough. However, the court found that there was misleading and deceptive conduct. So before investing in building a brand, including signage, packaging, a website, or a campaign, businesses should seek holistic advice by conducting trademark searches and also considering whether your get-up and messaging are sufficiently different from an existing business so that risks of misleading and deceptive conduct allegations can be avoided. And I'll revisit this in the case study. Okay. All right. So the second gap is that assuming the job is finished once the trademark registration is complete, but that's not the case. Classifications and classes need to match the way the business actually operates. Over time, goods and services that you provide might change, and it's really important to check that the class of goods and services is still up to date. You can't just add new goods and services to a registered trademark. You need to start again. Having the wrong entity listed as a registered owner is a really massive gap. An application must be filed in the name of the first user or controller. A mistake at the outset will make the registration defective, and it can't be rectified by assigning the trademark later. That, of course, doesn't mean that you cannot protect your IP by having it owned in one entity and licensed to another for asset protection purposes. But the key is that the owner needs to exercise control over how licensees use their marks. Seems elementary to say, but keeping track of your trademarks is also equally important. Sometimes when we come to renew a trademark, we find that the owning entity has been deregistered by ASIC because the owners have forgotten which company legally owns the trademarks. And that's a massive problem because it's very difficult to get a trademark out of ASIC because they vest in ASIC. So the next dot point and common gap is assuming that honest and concurrent use will excuse prior knowledge of an existing mark. In Zip Co and First Mac, the company called First Mac had an earlier registration for Zip in relation to financial services. So Zip filed an application and found out about First Mac's application when they received an adverse trademark report from IP Australia, but they ignored it and then launched their buy now pay later service under the Zip brand. When it went to court, Zip sought to rely on the defence of honest and concurrent use, but the High Court disagreed, stating that actual knowledge weighed heavily against a finding of honesty. In trademarks, keeping evidence of use is really important. If you haven't used your trademark in relation to each of the goods and services mentioned as part of your registered mark for more than 3 years, you risk an application for cancellation for non-use. So the message is use it and take pictures, or maybe you'll lose it. So the third gap I wanted to talk about is ownership. Businesses are creating more material using third parties or AI tools, and this is where ownership disputes can arise. For example, an agency may design a logo, write website content, or produce a campaign. Unless the agreement between the agent and the owner clearly deals with ownership, the business may only have permission to use that material rather than full ownership of it. Then AI adds another layer. A business might use AI to generate a name or an image or a campaign without checking whether the output is too close to an existing trademark or someone else's content, because, as we know, AI tends to copy what it knows. There are currently no reported Australian court cases dealing with copyright claims over AI-generated or AI-trained material, but the copyright laws require that a human author is involved in the creation of a work before it can be said to be copyrighted by that person. There is also a confidentiality risk. Staff may enter customer information, internal documents, or commercially sensitive information into an AI platform without considering where that information goes or how it may be used. So the practical question is, can the business show a clear path from the person or platform that created the material through to the business owning and controlling it? Be aware that the business might not legally own the AI creation. The gap often surfaces during a sale, an investment process, a dispute, or after the departure of a key person. So what to do now? There are 3 practical things that businesses can do. The first is to get clearance. Before launching a new name, product, or campaign or piece of content, engage a professional to conduct comprehensive searches of the market and check whether it's safe to use. And do that before spending a lot of money on branding, packaging, and advertising. The second is get control. Register important trademarks in the correct entity and make sure agreements with employees, contractors, agencies clearly deal with ownership, confidentiality, and the right to use the material. Also keep records showing how the brand is being used and who has authority to use it, and update those records regularly. The third is to monitor. Watch out for similar names, misuse online, and changes within the business. A registration that suited the business 3 years ago may no longer cover what the business does today. The main message is that registration alone does not answer every question. Ownership, use, control all matter, and work together to protect your brand and reputation. Your brand may be one of the most valuable assets in the business. So the question is whether you can prove that you own it, control it, and that you can stop someone else from taking advantage of it. So that's it for me for now. I will hand over to Evelyn Marcoux, who is going to talk about another key asset, which is your premises lease.